Mrs. Fox, because if you feel in your, it's too much to ask people. Respect is earned; it's not demanded or commanded. It's too much to ask people, in my opinion, to give unfettered respect. But I don't believe it's too much to ask to follow directions at the roadside, whether you believe they're wrong or not. Because many times, guess what? The direction is lawful and you're wrong and don't understand the law, but you may believe you're right. So is that belief, in many cases, which is false, worth risking everything for? It's really not. There's a way, a right way to do it, a right way to fix it, and that is not the right way.
If anything happens, call Captain. We're gonna fix it.
I don't know if I'm going to fix it, but I'm passionate about what I do. I'm passionate about it.
Unfortunately, me and my fiance had a chance to experience some a bad experience.
To answer your first part of your question, he can ask you anything. He can ask you, what color is the sky today? I mean, he can ask you anything. There's nothing really unprofessional or unethical about that. But you don't have to answer, right? There's only certain things you have to do in a traffic stop. You don't have to answer where you're going.
I wasn't aware of that because that was actually my first time being pulled over.
Right.
So I wasn't aware of what I could answer and what not, because him being an officer.
Position of authority, right? I understand.
I have respect for them, or for all of them.
There's a manner of roadside interview that's taught to all law enforcement officers, and we do ask a ton of questions, and it all pertains to determining the veracity of the person's interaction with you. When I say veracity, I mean their truthfulness. Are they being truthful? There may be certain things he may ask you or she may ask you that they already know the answers to. And they're asking those questions to see if you're going to be honest and forthcoming. And, and some of it in general is just conversation. It's sometimes awkward for the...
After this interaction. And next up to the podium, I'd like to call somebody else who's very important. This is our last person. Very important to the whole process of court, policing, and services to the community. It's Christopher Eisenmeyer, County Court Supervisor, Public Defender of the 8th Judicial Circuit.
Thank you. So I guess briefly for the people that walked in after I did my introduction, I work for Stacey Scott, who's the elected public defender for the 8th Judicial Circuit. I'm in charge of county court, which is misdemeanor offenses in Alachua County. I supervise 6 attorneys charged with charged with defending people who are facing misdemeanor charges. So that's my background. I've been doing this a little over 6 years now. I actually started as an intern while I was still in law school. Loved what I did so much that I decided to stay in the community and become a part of it.
All right. Did I say your last name right?
Eisenmenger.
Eisenmenger.
I've heard a little bit of everything.
It's called worse.
Yes. I haven't called worse. Chris is fine.
All right, Chris. Thank you. And thank you for being here today. I'm going to start with my first question, and it's pretty simple. What are some challenges facing public defenders?
Before I answer this question, let me say I love what I do. I'm very passionate about what I do. I think I do what I do. My job that I do is important, and the way I do it well. But I recognize that there's some challenges, and they're ones that I accept and try to overcome. And so please, as I answer this question, don't feel like I'm complaining or putting off some of my challenges on anyone else. I think there are 3 ways that it's difficult to be a public defender, but they all fall under the umbrella of we start in the hole. And when I say that, we start in the hole, essentially 3 different ways. Funding is a huge one, and I'll come to why funding is important as I explain my next 2 points. The other major one is client confidence. We don't have clients that believe that we are acting in their best interests. And I think that happens for 2 reasons. One, we're essentially given, is one way to put it, or thrown upon is another way to put it, the person that we're charged with representing. And there is a certain value to something that you either pay for or choose that you don't get with the public defender's office, because you don't get to choose who your attorney is, and you, other than the nominal fee, pay for our services. So if you qualify for our services, we're sort of thrown upon you. The second reason that we don't have client confidence is the same reason that some of the sheriff's officers don't have confidence, some of the judiciary may not have confidence, because it doesn't take but 1 or 2 bad assistant public defenders to leave a horrible taste in the community's mouth and make my job all the more difficult to overcome when interacting with the client for the first time, somebody that I may never have met before. I accept that. I know that that's part of the job, and that's why it's very important to me that when I'm interacting with the person is to gain their confidence as quickly as I can so that they can trust that I am trying to help them through the process. The third way that it's difficult to be a public defender is caseload. And we really, I'll say this, Ms. Scott has done an excellent job of making sure that her divisions are well staffed with attorneys. Funding, and I'll get back to my first point, would help, but we have a lot of cases. We don't necessarily have all of the time that a private criminal defense attorney would have to meet with people, to meet with family members. I, in part of what I do as the county court supervisor, preach efficiency in your caseload, which is different than speed, which is different than moving things through the system. You have to be a very good multitasker to be a public defender. You have to know what you're looking for, you need to go out and do it, and you need to be working almost 24/7. We are considered salaried employees. We're paid on the rate of a 40-hour work week. We work much more than 40 hours if we're doing our job correctly. And whether that be trial, jail visits with our clients who are incarcerated, legal research, meeting with each other to make sure that we're not missing anything in the case, we work a lot harder and a lot longer than 40 hours a week if we're doing our job correctly. The big one, and the one that Ms. Scott is very passionate about, is funding. And funding affects all of those other things that I've already talked about, because the more attorneys that we can hire at our office, the lower our caseload will be. The more ability we'll have to work on each case and not have to feel like we're multitasking, be concerned that we're missing something. And the reason funding is important is because the legislature funds us essentially in 2 ways. They give us real money, general revenue dollars that come from taxes that are collected by the state of Florida. And they give us trust funding spending authority. There is a trust fund. Anybody who pays the $50 public defender application fee or the $50 or in county court, $100 in circuit court public defender fee in our circuit, that money goes into a trust fund. And the legislature gives us the authority to spend money from that trust fund on the day-to-day operation of our office. That trust fund is not 100% funded, because as you can imagine, the people that are putting money into that are indigent to begin with and don't necessarily have $50 or $100 that they can pay into that trust fund. So we are given the authority to spend much more money than we have in the trust fund. And there are a number of other agencies that are funded in that manner by the state of Florida. I can't claim that we're the only ones that are funded in that way. So we don't necessarily have real money from both sources. We have an amount we could spend if we had the money in that account, and we have the real money. So Ms. Scott, we actually stole our office manager from court administration. They do a very good job of balancing that as best as they can. But the more money they have, the more attorneys they can hire, the lower our caseloads would be. And it would allow us to retain the good attorneys so that the community sees good public defenders helping people. And when you hear, oh, so-and-so has been assigned as my attorney, somebody else can say, that's a good public defender. I know somebody who had them, or I had them in the past, and they would take good care of you. So I think those are the challenges of my job. Again, I embrace them. I enjoy what I do. I've had some opportunities to do something else and chosen to stay with our office and keep doing what I'm doing. So I enjoy it.
I think those are pretty significant challenges, especially the funding section of the story, letting us know that everything is not waving magic on the money. I want to say from my personal experience, I've had the opportunity to sit in court in the back and watch you. You are a good public defender in what you do. And Judge Kolar, he's a good judge. I watch them all. I like to watch people before it. So you don't fit the criteria. It's bad to say this, but I'm gonna say it. A lot of people call it public pretenders.
Heard that.
Because you get people that feel like they want to treat properly. But I believe exactly what you said, more money, more funding will fix that problem, less workload. The second question is, explain the impact and purpose of plea bargains.
Well, this kind of goes back to what Judge Koloff was talking about with mandatory minimums and judicial discretion. The score sheet, the Criminal Punishment Code score sheet, one of the major ways that the judge can deviate from that score sheet is a legitimate uncoerced plea bargain. So that's a plea bargain. That's us meeting with the state attorney's office, trying to hash out some details. The reason that they're important is because there is a proposed resolution to the judge, which most of our judges in the 8th Judicial Circuit trust the attorneys, the defense attorneys and the state attorneys, to work out a resolution, to know all the finer details, and to present something to them that is acceptable to the court. That proposed resolution is typically fixed. If the judge, for whatever reason, doesn't believe that that's an appropriate resolution, the client can withdraw their plea and we can go back to the negotiating table and try to iron out the final details. So you're getting a guaranteed resolution of your case right there. It may call for probation, it may call for incarceration, but it is a guaranteed resolution of the case, and that's important because you're waiving a huge right, which is the right to a trial. So you should have some finality in understanding what the plea offer is. The other thing that often happens with plea negotiations is that people want some sort of finality. They want to know what's going to happen in the case. They don't want to take it all the way to a jury trial because they're concerned about what could happen after a jury trial. After a jury trial, the Criminal Punishment Code becomes much more important. The minimum mandatories become much more important, and the discretion of the judges, as Judge Koloff commented on before, gets narrower and narrower as we go along.
Sorry. Okay, because I was trying to remember. Okay, so with the score sheet and the judge's discretion being narrowed, only with a plea bargain does the score sheet not necessarily have to be followed.
Not only with a plea bargain.
Okay.
And
That's just the most common.
That's
the most common.
And
Okay.
the easiest way. The others
Yes.
are much more difficult for them to establish.
Okay.
There are a number of different ways. There actually, if anybody had a copy of the score sheet or wants to see one, they're on the Florida Department of Corrections website. They have what they call the Criminal Punishment Code Manual. Anybody can download and read through and see how the score sheet works. There's check boxes at the bottom of the score sheet, and those are the statutory mitigators, the reasons the judge can deviate from the score sheet. Currently under Florida law, and it's evolved over the years, but currently under Florida law, the score sheet creates a floor, and then the statutory maximum becomes the ceiling, and the judge has the discretion anywhere kind of between those two numbers, generally speaking.
Okay.
Minimum mandatories throw a whole nother wrench into that, and that's why, as Judge Koloff so eloquently said, it depends.
Yeah.
That's actually the first thing they teach us all in law school, is the answer to any question is it depends. But generally speaking, that's the way the score sheet works currently. That there's a floor, and then the ceiling is always the statutory maximum. So if you are submitting yourself purely to the will of the court, the judge has to make a decision between those numbers, and that's scary. Whereas a plea petition, a plea agreement, is not as scary. I'm not saying that it doesn't call for people to do things that impact their lives at all. I respect and understand that, and I understand it is a big deal waiving the right to a jury trial. But it gives some finality to it. The last step in the process becomes, will the judge accept this and sentence me to it? And if that happens, then you know what will happen based on the charge. It also allows us to charge bargains. So